Buckle up, guys. Today we're stepping into a courtroom where the opening line is Grand Rising, and somehow it gets even more surreal from there. Nicole Tubbs walks in like she's hosting a chakra alignment retreat, not answering to charges. She claims she's the beneficiary, SOVCIT speak for, I watched a bad TikTok. The judge tries to clarify that standby counsel is optional help, not a trap. But Tubbs calls it forced assistance, and demands to walk her divine path solo. She's voluntarily on a Zoom call but crying coercion. Irony has left the building. The judge remains calm while she invokes spiritual authority. Newsflash: the Holy Spirit isn't bar certified in Michigan. Her defense is less legal and more law of attraction.
All right, let's call a case.
Calling case 2400390201, the people of the state of Michigan versus Talia Nicole Tubbs. This matter is scheduled today for a pre-trial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
Good morning, Judge Deanne Patillo, P82378 on behalf of Ms. Tania Tubbs.
Ms. Tubbs, if you can state your name for the record, please.
Grand Rising. I asked the Holy Spirit to come in here and touch this courtroom today, and I welcome the Holy Spirit. I am Tania Nicole Tubbs, the beneficiary.
Okay. And Ms. Patilla is being appointed as your standby counsel, Ms. Tubbs, all right?
No, sir, I did not ask for that. But if I'm being forced, then I'm being forced in direct coercion.
All right. Well, I'm not forcing you, but she's going to help in case you need anything. You don't ever have to use her, but if you want any questions on anything, she's there to help you, okay? You're gonna represent yourself, but if you have any questions, you can ask her, all right?
I hear you, sir.
All right. Do we have a jury trial date on this?
March 7th.
All right. We'll set this is set for jury trial on March 17th at 9 a.m. Ms. Tubbs, did you want to discuss settlement with the prosecutor, or do you just want to go ahead to jury trial?
I wanted to ask the prosecutor a few things, if you don't mind.
Okay.
Your Honor, one of the things I think that we put on the record last week when we were trying to establish whether Ms. Tubbs was going to represent herself, if we were going to relieve the prior defense counsel of his obligations and then also get standby counsel. And I think that today was more of an update just to make sure everything was in order, but knowing that the trial
and I have ruled that she can represent herself, haven't I?
Yes.
Okay. All right.
And that's why the other counsel was relieved and
Right. Okay.
Ms. Patillo was put on as standby.
All right.
With that, I think that we had mentioned the possibility of having Ms. Tubbs be brought over here so that we can have discussions. Ms. Patillo is standby. I feel comfortable speaking to Ms. Tubbs as long as there's somebody else there. Even if they're not fully representing her, at least there's a third person. And I wouldn't mind speaking to her in person, but I think it's going to be easier if she's here, and I don't necessarily want her to say something on Zoom in open court that might affect her case when she's representing herself.
All right. We can do this one of two ways. Either can put all of you in a breakout room and let the three of you discuss things, or we can bring her here.
I would ask Ms. Tubbs what she would like to do.
Ms. Tubbs, what do you want to do? Do you want to go into a breakout room with the standby counsel and and the prosecutor, or would you like to come here physically to talk with them?
I can do standby counsel. I mean, I can do not standby counsel, but I can talk to them in the break room since she's afraid of what I have to say, so the public.
All right, guys, this courtroom just turned into a Sunday sermon with legal consequences. Tubbs claims she's not alone. The Holy Spirit helps me, she says, as if divine intervention counts as legal representation. The judge responds with a classic legal warning. Self-representation is a dangerous game. But she flips it, saying only a fool would not trust divine guidance. At this point, We're watching courtroom improv with spiritual fanfiction. Even the prosecutor taps out and requests a private breakout room. Tubbs resists, again calling it forced, and demands total sovereignty. She only agrees once conditions are tailored like a cosmic prenup. And just to be clear, this is still pre-trial.
So if I could interject, I apologize, Your Honor. Would I be able to, well, if Ms. Tubbs allows, would I be able to speak to her before she speaks to the
I don't allow.
That's an excellent idea. Ms. Tubbs, would you be willing to speak privately with Ms. Patella?
No, sir.
All right, Ms. Patel, I don't think I can order her to do that, so, Ms. Tubbs, as I told you before, we got taught the first day of law school, he or she who represents themselves as a fool for a client. I would strongly recommend that you talk to Ms. Patella, but if you don't want to, you don't have to. What would you like to do with that?
With all due respect, sir, I am not working alone. I work with the Holy Spirit, so only a fool would think that the Holy Spirit ain't helping me.
Things go full sovereign citizen in part 3. Tubbs now calls in from jail, but insists she's not subject to any legal entity, while wearing a facility-issued jumpsuit. She won't even acknowledge her own name, referring to herself as the beneficiary of the account. She refuses transportation to court unless she can walk there as a freeborn sovereign. That's a strong stance for someone surrounded by steel bars. The prosecutor tries to schedule her appearance, but Tubbs derails it with sovereign gibberish about filings in a separate courthouse. She's not just dodging court, she's actively building a fantasy where she's always the victim and never the defendant. Reality isn't just optional, it's unwelcome.
Not being smart.
All right, and I'm not being smart with you either. I'm telling you what they told us in law school, all right?
That's understandable.
All right, that's fine, Ms. Tubbs. So she apparently, will you be willing to have Ms. Patella in the room with you and the prosecutor?
Sir, I do not need her. Thank you. I'm not willing to.
All right.
I want somebody.
Yeah.
Regardless
so the
of who it
prosecutor
is.
says she does not feel comfortable talking directly with you without somebody else in the room. So
You're
you tell
forcing me. You're forcing
I'm
me
not
to have.
forcing you to do anything. You know, you don't have to talk to me. We can just go ahead and have a jury trial. That's fine with me. So what the prosecutor is saying is if she wants to talk alone with you, that there has to be somebody else in the courtroom or in the room. So you tell me.
She can have her in the courtroom, but not on my behalf. It can be on her behalf since she's fearing what I have to say alone. I'm not understanding why.
Put the three of you in a breakout room to discuss things.
Okay, thank you.
Do you agree to that, Ms. Tubb?
I agree to speak with her with the third party on her side.
All right. And counsel, how long do you think we should put you in the breakout room for?
10 minutes to be safe.
10 minutes, and then you can have more time if you need it, okay?
Okay, thank you.
I'll take 5 minutes.
Okay, well, I'm gonna put you in 10. You can always stop early, okay?
Thank you.
A few moments later.
All right, let's call Ms. Tubbs' case, please.
Calling case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
And good morning, Judge Deanne Patillo, P82378, stand-in counsel for Ms. Tanaya Tubbs.
All right, Ms. Tubbs, if you can unmute and state your name for the record, please.
For the record, I am Tanea Nicole Tubbs, the beneficiary of the account.
All right, Ms. Tubbs, you have a constitutional right to be physically present for this hearing. Do you agree to waive that right for today and hold this hearing by Zoom?
Correct.
Okay. All right. Where are we at on Ms. Tubbs' case, Madam Prosecutor?
Your Honor, I did get some information from Ms. Tubbs, and I did look up I know that the defendant is in Calhoun County Jail right now. in that, she has a sentencing date of March 24th, 2025. When is our trial date? The
March
17th?
17.
I'm guessing that Calhoun County would let her come here pending their sentence, since we have a trial date. I don't know how that all works because their case is a 2022 case, so it's definitely older. But either way, that's a problem for somebody else, I suppose. I think that Miss Tubbs needs to be brought over here, and maybe we should have a pretrial before the trial once Miss Tubbs is here, where we're all in person. And Miss Tubbs can bring whatever documentation that she wishes to provide at that point. That way we all have it, and we're all on the same page, because some of the things that she's referring to, I do not have. And I would say that we're likely going to have to proceed to trial.
All right. When are you proposing that we have this, bring her over beforehand? Obviously, the closer to the date for the court's purposes, the better, because we don't have to retain her as long from Calhoun. But if you think it would help to bring her earlier, we can do that too.
I think that approximately 2 weeks before, so that puts us in the March 3rd area. Sometime at the end of the week before or early the week of March 3rd.
I'm available the 6th, if that works for the court, prosecutor and Ms. Tubbs.
All right, why don't we schedule this to have her brought over here for March the 6th, and we'll have the hearing at 11:30. Is that time okay for you, Attorney Patella?
Yes, Your Honor.
All right, we'll set this for March 6th at 11:30. Hey, May, can you send a writ to have her brought from Calhoun County here?
Yeah.
Okay. All right.
Excuse me, Your Honor.
Yes, go right ahead, man, Ms. Tubbs.
I am looking forward to being out of here before then. And, it is my duty to come there on my own as a freeborn sovereign, to this. I do not need to be detained or retained. I am not an entity or subject to any entity. And I gave this paperwork to the 36th district, and I'm not going to be able to get this paperwork if I don't be able to walk and go get it, go home and print it out myself, because I have number 8 children. I am by myself. I don't have support. I just have myself and my 8 children, which my oldest just went to prison, so he's not able to.
Get ready, guys. This part swings from sad to absurd in seconds. Tubbs reveals she has 8 children, no support, and her eldest is already in prison. That should be a wake-up call, but instead of protecting her future, she's still playing sovereign games. She says she can't share documents unless she's free to use a printer herself. The court offers a ride. She responds with, "I don't need to be detained or retained." Her rhetoric sounds like a dream journal entry from a pseudo-law retreat. This is where tragic real life collides with delusional legal cosplay. She's trading her children's well-being for conspiratorial nonsense, and the judge knows it.
All right, well, we'll see you on March 6th at 11:30. You have a nice day, ma'am, okay?
So there is no holds on me, correct?
Well, you're going to be in the jail here, Wayne County Jail.
What I'm telling you is that I'm going to be released from here either today, tomorrow, and I do not need any holds to come to another jail. I am a freeborn sovereign. I do not need to be detained or retained. I am not subject to any entity or am I entity.
Now entering the arena, Kamash Myrick, armed with zero legal knowledge and maximum confidence. He kicks off with the classic SOV line, "I'm making a special appearance." Translation: I don't think the rules apply to me. His own lawyer says he doesn't want representation. The judge calmly tries to explain his rights, including that driving on a suspended license can land him in jail. But Myrick isn't here to listen. He's here to demand the court prove its subject matter jurisdiction. This isn't advocacy, it's theater. And unfortunately, The legal system doesn't give awards for delusion. The judge remains poised, but you can feel the patience wearing thin.
You're going to have a chance to speak with Attorney Gagnick before the arraignment. And you'll see on your screen an invitation to join a breakout room. And we're going to go to breakout room 2. So when you see the invitation to join, please join.
Magistrate, Mr. Myrick declined counsel.
Okay?
I'll just have him acknowledge on the record, and then I'll let you take it from there.
We've got Mr. Myrick coming back. We'll close the room.
I get the impression that he may be filing a special appearance on behalf of a sovereign citizen.
Okay, we've got Mr. Myrick back. This is 25-00183. People of the City of Berkeley versus Kamash Daku Myrick.
Magistrate, I'm just going to acknowledge my presence for the record. Patrick Gagnick. I'm here as appointed counsel on behalf of the arraignment docket this morning. I did speak to Mr. Myrick in private. I did explain to him he does have the right to counsel. I explained to him, obviously, that right. He's indicated to me unequivocally that he does not want counsel. Mr. Myrick, is that a fair statement?
That is a fair statement.
So with that said, I'm here and present, but with that, I believe Mr. Myrick will address the court on his own behalf.
Mr. Myrick, you have the right to decline counsel. You also have the right to change your mind. If you do, just notify the court.
Yes, sir.
You've been charged in this citation that was issued on the 22nd day of January at about 5:58 in the morning with driving in the city of Berkeley on Henley near Franklin Street while your license to do so was suspended. Driving on a suspended license is a crime for which you could be incarcerated up to 93 days and or fined $500. You have a right to a trial. Trial can be before a judge or a jury. You can act as your own attorney or you can be represented by counsel. If you cannot afford to retain your own attorney, an attorney can be appointed for you. You'd have the right to confront and cross-examine the witnesses against you. You'd have the right to testify yourself or not to testify. In the event that you choose not to testify, your silence cannot be used against you. You have the right to be presumed innocent until you're proven guilty beyond a reasonable doubt. The court's going to enter a plea of not guilty on your behalf.
No, sir.
And here comes the spiral. Myrick goes all in. He demands to know whether the court is operating under common law or admiralty jurisdiction. He's not joking. He thinks he's on trial for piracy. The judge explains this is a Michigan court following Michigan law. But Myrick is deep in Article 1, Section 8, Clause 17, misapplying it like it's a legal cheat code. He wants a full legal definition of jurisdiction, moments after he just butchered it himself. This isn't courtroom defense. It's parroting nonsense from sovereign citizen forums. His logic loops faster than a bootleg law seminar. The only thing he's sinking is his own credibility.
On the streets of the city of Berkeley while you're not licensed. You're suspended. That's the allegation.
Well, I totally understand, and I would love to plead, Your Honor. But before I have some questions on the record before moving forward and concerning the subject matter of the jurisdiction and the nature and cause of the action that's brought against me.
The nature of the cause brought against you is a criminal charge.
Okay.
Alleging that you were operating a motor vehicle on the streets of the city of Berkeley while your driver's license was suspended by the Michigan Secretary of State. That is the nature of the charges brought against you.
Thank you, Your Honor. For the record, are you saying that these are criminal charges?
Yeah.
Okay, Your Honor. Further, that brings a little bit more confusion for me because under the Constitution, there are two criminal jurisdictions. One is under the common law, and the other one is under admiralty, and that's a military tribunal venue. and under Article 1, Section 8, Clause 17.
Guys, welcome to the climax of courtroom absurdity. Myrick objects to logic, procedure, and apparently gravity itself. The judge tries to enter a not guilty plea, a standard arraignment step. Myrick jumps in with, "The people are not a person," and demands the Constitution require understanding. He claims only 2 criminal jurisdictions exist and keeps circling the same 3 broken legal phrases like a carousel of confusion. The courtroom has now become a free-range conspiracy showcase. The judge, fed up, sets bond and dismisses him from the hearing. Myrick, still oblivious, tries to move to dismiss. You can't dismiss a room that already booted you out.
And its implications is grossly distorted. You're not dealing with reality.
Objection, Your Honor.
You can object all day long, but the bottom line is that what you are alleged with doing is a crime, and you are facing criminal prosecution here with a potential jail sentence of 93 days. Now, this isn't complicated. If you want to come up with words that don't make sense, keep talking. But the bottom line is that there's no correlation with what's going on here and admiralty law whatsoever. And the common law is a civil concept. We have statutes in the state of Michigan, as do all 50 of the states. The federal courts have statutes, and common law is a civil thing. There's no common law crimes.
Exactly. So you've ruled out the common law, Your Honor. So the other criminal jurisdiction that I can be brought in charges under is under admiralty, and that is a military tribunal.
There is no basis in law or fact for the conclusion that you stated, sir.
Your Honor, you said that I'm under a criminal. This is a criminal charge, correct?
Yeah.
So which of the 2 criminal jurisdictions?
You haven't heard what I've said, sir. This is not a matter of having the 2 choices that you have spoken to.
Wow.
You are misreading the Constitution of the United States, the Constitution of the state of Michigan, and the statutes that are brought against you here. There's nothing to do with admiralty. You weren't in a boat.
Well, Your Honor, you too have a sworn oath of office, correct?
I am sworn to uphold the Constitution of the United States, the Constitution of the state of Michigan, and the statutes related thereto. And that means that I'm not going to.
So you do have a Sixth Amendment obligation to inform me of what jurisdiction.
And I think I have done that. I have told you that the people of the city of Berkeley have brought charges against you.
Well, Your Honor, the people is not a person. If I'm being brought up under criminal charges, there needs to be a corpus delicti, which there isn't.
You keep using the word. I don't think it means what you think it means.
So I'm asking you.
Do you know any other legal words? Why don't you just mix and match them here?
Well, this
maybe you could get a Department of Labor form and read a couple lines of that into this record too. Or maybe you'd like to deal with the probate code. But the reality, sir, is that you've been charged with a city ordinance violation. It's clear what the ordinance says. It's clear what you've been charged with. You have a right to be presumed innocent, and you have a right to a trial. We're going to set this for a pre-trial before the trial. You'll be notified by mail. Do you still live on Mendota?
I do, but I have.
What is your phone number?
I'm not issued a plea, Your Honor.
I have entered a plea of not guilty on your behalf.
I object.
What is your phone number?
You cannot enter a plea. I do not. I have not entered a plea.
I just did.
Your Honor.
What is your phone number?
There is no plea that you can enter in because I didn't voluntarily enter in the plea, Your Honor. I'm asking you, Your Honor.
You want me to enter a plea of guilty?
Under the 2 jurisdictions that
there's not 2 jurisdictions.
There's only 2 jurisdictions that I can be charged under the Constitution,
no, that's
Your Honor.
Mr. Myrick. That's what your conclusion that there's only 2 jurisdictions here is absolutely without merit. in
Your Honor,
fact
you said
or
that this
law.
was a criminal charge. I'm asking you, Your Honor.
I'm asking you what your phone number is. Let's get down to basics here. You're making this very hard on yourself.
Your Honor, I
What's
have the
your phone
right to
number?
assert my right, Your Honor. And
What
I am
is your
asking
phone
you,
number?
Your Honor.
What is your
What
phone number?
my phone number, Your Honor, is
Yes, I'd like to know it.
Your Honor, we haven't even established what jurisdiction we're in.
I have established that. I told you it's the people of the city of Berkeley that brought the charges against you.
Your
You've
Honor,
said that three times now.
you stated on the record that these were criminal charges, Your Honor. I need to have
Correct.
an understanding. By the Constitution, Your Honor, there are only two
Where
criminal
does the
charges.
Constitution say you have to have an understanding?
Say again, Your Honor?
Where does the Constitution say you have to have an understanding?
By the Sixth Amendment, Your Honor. The
Sixth Amendment says you have to
the right
understand. The Sixth Amendment can't make you understand if you're being unreasonable.
But, Your Honor, I have the right to understand what jurisdiction that I'm being brought under, and you have an obligation to inform me of that jurisdiction, Your Honor.
Which I have done about 17
by the
times.
Constitution, under Article 1, Section 8, Clause 17, Your Honor.
Mr. Myrick, your bond is $1,000 cash or surety. It must be paid within 48 hours or there'll be a warrant issued for your arrest.
Your Honor.
That's done. We're through. Good luck.
Your Honor.
Get your own lawyer.
Your Honor, you have not given me a jurisdiction, Your Honor.
I've given you a jurisdiction 4 times. I'm not going to waste any more time.
Just when you think it's over, Myrick returns, uninvited and still unqualified. Like a horror sequel nobody asked for, he logs back into the hearing as if nothing happened. The judge lets him know, "You were removed for wasting time." Myrick starts again, "I move to dismiss." At this point, it's like watching someone try to unplug a fire with a spoon. The judge, visibly done, tells him to come to court in person if he wants answers. Myrick wants a courtroom but on his terms, with sovereign scripts and imaginary legal shields. But this isn't fantasy camp. The courtroom has rules, and Sovereign Scooby-Doo just got benched.
Your Honor, I think you, there was a disconnection or something?
No, I disconnected you. If you want to continue, come to the courthouse, sir.
Your Honor?
Come to the courthouse if you want to continue the conversation.
I would like to move for dismissal.
I would like, it's not going to be, no.
I would like to move.
You're gone.
She's a beauty, we're talking. Oh my God.
Strap in, it's Sovereign Karen's time to shine, and she's coming in hot from Facebook jail. She says she wasn't arrested, she was coerced. She didn't miss court, she submitted paperwork. Her logic is a puzzle box made of internet nonsense. She claims courts are banks, the US is a corporation, and she's a non-resident alien. Her entire argument reads like a Reddit thread with 0 upvotes. She references USC codes like she's doing slam poetry at a conspiracy convention. The judge listens, but you can feel the disconnect. She's not arguing law, she's reciting fantasy like it's gospel.
Hello, everybody. How you doing? So I went to court today for a bench warrant to deal with a bench warrant that was put out for me, allegedly because I didn't make an appearance in court, but I did turn my paperwork in for that. You're allowed to turn in paperwork. You don't have to physically go to court. Paperwork is the same thing as making an appearance. They struck it from the record that I made my appearance. They struck the recusal of the judge from the record, and on top of that, they sent me a letter and they stated that I wasn't who I said I was, that I am who they say I am, which when I asked questions about that, the judge yelled at me and told me he didn't have to answer any of my questions. And then when I asked for the bill of particulars and the indemnity bond, I was arrested and taken into custody and held against my will. And so that's a false arrest. But not only was that a false arrest because it's all based on fraud in the first place, but secondly, they didn't read me my rights. I wasn't read my rights by the judge in the court, and I also wasn't read my rights when I was arrested. Also, they did not tell me what my charges were. So there's that. I can't wait to get the paperwork where they tell me what they're charging me with. So this is all because of the right to travel. Okay? It's all based on the right to travel freely, unencumbered, and unfettered according to the Constitution. Now, I'm going to pull up some stuff for you because people need to know what the truth is, and they're not going to really know unless I actually physically show them, because you guys, you're not going to do the research, right? You don't really care. You're just going to tell me I'm crazy, and nothing that I say makes sense.
And we close with a SOVCIT mic drop. Karen continues, now armed with folders, printouts, and UCC codes like she's preparing for a mock trial Renaissance fair. She talks about indemnity bonds and bills of particulars like they're keys to some sovereign treasure chest. She claims she wasn't told her charges, despite all evidence to the contrary. Then comes the cherry on top. I'm not a resident of Ohio, she says, from jail in Ohio. She insists she's educating the people, but she's only revealing how deeply people can spiral when ego, misinformation, and sovereign nonsense mix.